Further hearing in the appeal Gol Linhas Aereas against MatlinPatterson Global Opportunities.
Good morning. Thank you.
The Lord may recall, I was making a bit of Horlicks of the answer to the question what law the tribunal was entitled to apply to fill the gap of the ICC rules. In particular, the question whether the tribunal was entitled to apply INC and its corollaries. It was pointed out to me yesterday very helpfully that clause 14.6 on page 693 appeared to give some assistance. And looking at it, you can see that it's not just governing a clause that deals with the proper law of the agreement, but it also says that the tribunal will decide on disputes and disagreements in accordance with the laws of Brazil, ignoring any other rule of international private law that may cause the laws of any other country or jurisdiction to be applied. So that's a very strong indication. I agree I should have accepted straight away, which explains why the tribunal was entitled to apply Brazilian law of procedure.
Can we take to 14.1?
Yes, my lord.
Because that says all disputes will be resolved by arbitration in accordance with provisions of law 9307, the arbitration law. Yes. Could that not be said to be an agreement that the arbitration will be conducted in accordance with Brazilian arbitration law, which would include Article 21?
Yes, absolutely. Absolutely. I mean, Article 21, we've taken it as a given that Article 21 applied, Article 8 applied, that the tribunal would have to be reviewed under Article 32. All those, we take the Brazilian arbitration law as a given.
Is it appropriate to take it as a given?
Well, that it applies, for example, to an application to vacate a vacator action, yeah. Article 32. Article 8 gives the tribunal the competence jurisdiction. Article 21 Article 21, paragraph 2 is the provision that imposes an obligation of due process. And we've always assumed that the tribunal was bound to apply due process. What that means is another matter. I'll come to that. But all that 14.6 does is it buttresses that because it doesn't tell the tribunal how it's to make decisions unless you go to 14.6. The ICC rules don't tell you how to do that. The arbitration law doesn't tell you to do that, any more than any law tells an English court that there's cross-examination and that the judge goes away having heard submissions on everything. That's just a principle that's inherent where we grow up with it. They grow up with INC. It's not written anywhere. You can see textbooks that explain it. You can look at Michael Zander to see how we do how the English legal system works, but it's not written in any book and not any code, any more than our system is. I should also just give you a couple of references. The judge specifically referenced 14.6, the Brazilian judge. That's at 2298. And the Court of Appeal also referenced that paragraph at page 2415.
Just have a look at those.
Yeah. It's in, if you look at the paragraph beginning the second aspect, about halfway down, you see a reference to clause 14.6 with a 5.
What page is that, Mr. Lay?
2298, my lord, sorry.
This is in the judgment?
That's in the judgment. When he's dealing with remember, even the pursuant to 14.65, which I think is a misprint, the contract would be construed and governed by laws of Brazil, and the arbitration court must apply in the event of a dispute.
Yeah.
and the Court of Appeal quotes that at
Well, that just seems to be saying that
governing law.
the governing law is
Yeah,
the law of Brazil, which is obviously relevant when you have to decide whether the fund became a party or not.
yes, but he's clearly, absolutely. All I can say is he's looked at that clause. He has not read it out. It's not completely translated, but it's referenced. And then in its reference when he applies INC, in the previous few sentences he's looking at it from the point of view of INC. It doesn't. I mean, this is more question for you than for that judge. But the courts there clearly applied INC in determining that the tribunal had acted properly. They said so. So in a sense, that issue is also covered by an estoppel.
Well, it is as far as the Brazilian concept is concerned, but
Yes.
that brings us to the question of what legal standard the Cayman Court applies under Article 151B, which we're probably coming to.
I am, but I'm just answering the question I made a Horlicks of yesterday. So this was the point. The point that was drawn to my attention was I might be assisted by 14.6. I accept the invitation to say I am assisted by that. I point out that the judges referred to, and the Court of Appeal referred to. In considering whether the extent to which the laws of the seat apply to procedure, it's worth mentioning that Article 5 itself, Article 5(1)(c), refers to the law of the place where the arbitration takes place, and I think one of the other paragraphs does too. And would you like to just be?
Yeah.
Yes, please.
Yes, but the other subparagraphs don't.
The others don't. No, B doesn't. Sorry, it's in
2822, I think, in the electronic file.
Thank you very much. Yes, it's in A and it's in C, but not in B. I mean, B doesn't refer to any particular law. And you've been sent.
As far as D is concerned, you can say that it can't be said that the arbitral procedure was not in accordance with the law of the country where the arbitration took place.
Yes, okay. Thank you.
However, that's a different requirement from B.
Yes.
But C doesn't either.
CC?
C doesn't have a law built into it.
No.
No, D does. And I mean, I didn't receive, I'm afraid, the magnum opus yesterday because it was sent to an email address that doesn't work for me. But may I reserve my position and send you something? I very briefly read it before you came in. There's obviously a lot of debate about what law you apply for the purposes of Article 5B. But at the moment, what I was addressing was whether the tribunal was entitled to apply local law in the confines of the arbitration to determine matters. So I'll come to the other question in a moment. Not sure I can do very much more than I did yesterday on that question that's addressed by the Bourne article. The other reason why the tribunal would have been justified in applying INC and the adversary principle is because they appear to be linked to the Constitution. If you can just look at page 444. Which was the examination of Mr. Santos. I've got the page right. I'm so sorry. And 454, I think he deals with it again.
454.
454, he deals with it. Yeah, he deals with a constitutional point. He says that it's INC and the Constitution have worked hand in hand together since '88. He's talking about the introduction of a specific provision.
So where are you asking?
On page 161 of the transcript.
All right.
But there was an earlier reference I'm just trying to find.
What is this constitutional principle?
The principle of...
You don't have a right to be heard before the case is decided? Basically.
But it's always worked hand in hand with INC. So the tribunal, thinking about the right to be heard, and INC would be applying a concept from general law. And so that's another reason why you might have, because it's an important principle in their law, an important...
Well, I think you have to, if you want us to take it into account, probably need to do better than show us a couple of lines from...
I do, I agree. But
a question in cross-examination.
I do. I've lost my reference. Okay. There's a one part of his report which also deals with it, but I'll try and find that. Anyway, I could just point out that, I mean, this is just a forensic point, but in the court challenge, in the arbitration final reply, the MP funds also referred to Brazilian procedure and made a claim for their fees on the basis that the claim had been brought maliciously, and they did that under Brazilian procedure. That's the reference to that is that 1944 to 1946, they made a claim for bad faith under the Code of Civil Procedure, paragraph 253 to 255. There was a debate at the trial about whether or not INC applied at all to international arbitrations, and you may have seen that the judge dealt with this. She deals with it at page 81. She's referring back to page 72, where she accepts or purports to accept two paragraphs in Mr. Santos's witness statement. The Court of Appeal doesn't refer to this debate. And
which two paragraphs are you referring to now?
179.
Yes.
On page 81 is the paragraph where she accepts and refers back to the earlier. And what she's referring to, paragraphs 24 to 25 on page 72.
Yeah.
She doesn't refer to 14.6. She doesn't refer to any of the debate that occurred around this point. And the Court of Appeal doesn't refer to this point. The reason the Court of Appeal doesn't refer to it, at least as far as my recollection is concerned, and as far as the transcript confirms, is that there was absolutely no argument directed to it. I recall my learned friend not pursuing this point in the Court of Appeal. Remember that I had a leave to appeal application, half an hour, followed by a 2-day appeal when leave was given. And we put in skeletons, but this didn't appear in the oral argument. It appeared in the written argument. My recollection is my learned friend abandoned it. But I should just very briefly tell you what the evidence about it was. Since it's a point that's arisen, I can try to do so as quickly as possible.
The point is
it's not a live point.
It doesn't apply to international arbitration as opposed to domestic arbitration.
Yeah, that's the point that was made.
Yeah. Well, and the answer to it was by reference to Article 14.6, was it? Or
Well, the answer to it was by reference to Article 14.6, and also because Mr. Santos, who gave this evidence, really had no support for it. What he says, much of what he says, I'll give you the reference, page 210, without reading it out to you, 210 to 211, paragraphs 515 to 520. Much of what he says is just argument. It's just sort of, I think it's unfair, that sort of argument, the sort of arguments that were put to me yesterday in the absence of any real hook to hang my point on. At first he said, the reference to that is on page 210, paragraph 513, that I and C didn't apply at all. But then he agreed in cross-examination that it did. At page, well, he agreed actually in a subsequent report of his affidavit, which is at page 270, paragraph 410. He agreed with my expert that it did apply. I&C did apply in international arbitration. Having said it didn't. And the judge.
Sorry, what's the reference for that?
It's page 210, paragraph 410. Sorry, 270, paragraph 410.
270.
We went through his authorities in cross-examination. At page 211 of the witness statement, paragraph 5.21, he relies on a case called EIT. The Court of Appeal dealt with this at 146. Yes, 146. Paragraph 160. But in any event, Santos agreed in cross-examination. The reference is page 450, internal transcript page 146, lines 10 to 15, that it wasn't argued that the ICC arbitration excluded general principles of Brazilian law in the case that he produced. In fact, the case really showed the opposite of what he was saying. He also agreed that the ICC guidelines were not binding. My learned friend agreed that, so I don't need to take you to any other aspect of it. That was one of the points he made, authority he relied on page 211. And then thirdly, he agreed that there was nothing else on which he could support this view, and the reference to that is in the transcript, page 454, internal transcript page 161, lines 19 to 162, line 6. He didn't have any authority for his view. It was his view. His view as an arbitration lawyer who in 10 years had only appeared in 2 vacator actions. So he hadn't got a huge amount of experience of reviewing tribunals like this. Although I'm sure he was very experienced in appearing in arbitrations. And the judge didn't grapple with any of this when she, at page 81, paragraph 179, accepted the witness statement without criticism. So those are my submissions on why it was appropriate in Brazil for the arbitration tribunal to apply INC and whatever goes with it. So that brings me to the next question, what is INC? Santos produced an exhibit, which is at page 633. It's an article that he referred to, starts at 625. But 633 sets out I mean, if you look at 632, the top paragraph, you'll see a sort of summary of it. And then at 633, under the heading consequences, you see going over the page 4 subparagraphs, which he agreed were accurate, an accurate reflection of what INC means. And the reference in the transcript to him agreeing that is at page 444, internal transcript reference 122, lines 10 to 22.
There's obviously a difference, isn't there, between saying the judge is not bound by the legal characterization of the facts proposed by the parties, what this is saying here, and in saying that the judge can decide the case on the basis of a legal theory that the parties haven't been given an opportunity to address. Those are two different points.
Yes, INC is essentially the judge's power to characterize the facts.
Yeah.
And he can do that. He's not bound by what the parties say. And what you have to, it isn't right to stop there and say you don't have a right to be heard or warned. There are 3 principles which protect the parties. The first is it's just to go for the least important first. The first is the right, it's the rule that prohibits the judge from going beyond the facts pleaded and the relief pleaded, which gets rid of the problem in min-metal. His role is to characterize the facts and so on. Santos dealt with, this is the points about petitum and causa petendi and so on. And Santos's cross-examination about that is between pages 441 and 443.
Would you like us to look at that?
No, because we dealt with it yesterday, and I think I'd just be wasting your time, unless you want me to show
No,
you.
that's fine, thank
I think
you.
you have the point.
I don't think it's suggested anyway that the tribunal here won't be on the facts.
No.
So there's the first protecting principle.
Yeah, although in arbitration it's relevant that what is the claim? What's the petitum? The petitum is for a Brazilian is what you put in the prayer.
Mm-hmm.
It's also, Santos also agreed, and this is at page 442, transcript reference 116, lines 8 to 14, that it's not essential for a party to set out legal characterization of the claims in a pleading or argument. Not essential. The second point, the second principle that's important is what they call the principe du contradictoire, or contraddittorio, and I'm just going to call the adversary principle, that everyone has the right to contradict the case of the other side, to present their own characterization of law and to say more or less what they like. And the third principle, which is important and is the principle that concerns you, is that as a party although a party is expected to anticipate how a court might characterize the facts, that is subject to it not being required to anticipate unforeseeable surprises.
I just make sure I'm not required to anticipate unforeseeable surprises.
Yeah,
Where do you get that from?
I'm going to show you.
You don't have to foresee what's unforeseeable.
Yes.
Yes, we can say talk about it. Yeah.
I mean, the basic, in actual fact, this is part of the adversary principle. You could look at it as a separate rule, but it's really bound up with it. The basic principle is described by Carmona at page 2613. This is evidence he gave in the US.
paragraph?
He said it will perhaps start at 16. 16, 17. He goes on to 19. He does 20. He doesn't deal on page 16. He doesn't deal with surprise because he doesn't accept in the context that there was surprise. But it's just to deal with show you what the adversary principle, how it's looked at. And this was adopted in his evidence in Cayman. Santos's evidence went the other way, much further. He said that every argument had to be disclosed to the parties, and you'll find that at page 209.
209.
209. He deals with this at 512 and 513, especially 513. The footnote that he quotes for that doesn't get him there. He deals in paragraph 512, page 209, with the introduction of Article 10 of the Brazilian Code of Civil Procedure in 2016. And it was agreed between us that Article 10 was introduced to try and reflect, codify the adversary principle that had operated at that Brazilian common law effectively before that. Back to the text he exhibited, and we now look at page 648. We can see that, in fact, at least prior to the introduction of Article 10, which is what happened with the stage we were at, the second paragraph, the adversarial proceedings also contain that which was agreed to be called the principle of no procedural surprise, which prevents the parties from being negatively surprised by unexpected decisions and are not able to participate. For a long time, this principle has been invoked by doctrine as a limit to the unilateral exercise of power of the judge. So before 2016, and you'll have seen in Switzerland, for example, that's the principle. I'll show you that by reference to the book. Bernard Ricks dealt with it. It's the principle of unforeseeable surprise. Because if you try and marry up the adversary principle with the right of the judge to characterize, you have to have that as a compromise, and that's what they did before they introduced Article 10. And ultimately, Santos agreed with that. His evidence at page 445. Transcript page 127, line 7 to 10. And then a bit later, page 453. Transcript page 160, lines 11 to 19. He says it again. Now, my lord yesterday suggested I give you some references to the book on INC, which you looked through. I'm sorry you had to do that unaided. But
No, I didn't actually look through it. I only read the summary at the end because it seemed too much a trawl. I was hoping you'd save that by giving some references.
Well, what I commend to you is, my Merton friend accuses Sir Bernard of illegitimate research. What he says about the various jurisdictions at page 135 following, I think he deals with, it's not 135, sorry. It's page 146 following. He looks at the treatise at page 145, paragraphs 1458 to 159. His survey is Brazil, starts on page 146. He looks through the chapter on Brazil, and he gives page references. Those are internal pages. So I'm happy to give you the electronic page if you want, but on each of these. But I thought maybe that would be sufficient for you.
Yeah, all right, thank you.
There are no further passages you want to show us?
No, there aren't, because he actually picked out the ones that we would have referred to. The Swiss, I would like to draw your attention to paragraph 164, because Switzerland, as you know, is a major arbitration jurisdiction. And Switzerland has the same rule about surprises. And there's just one, I mean, it is no more than illustrative of how that works. It's not a precedent of any kind, but at page 4617 in the original, there's a decision of a court, federal court in Switzerland, hearing an annulment action. The translation starts at page 4610.
4610.
Is the English, yeah.
Thank you.
And the relevant part of the decision is at page 4614, paragraph 5.2. And obviously the facts are unimportant, but you can see that it's a specific, my learned friends mentioned the provision in their case as well, but it's clearly a specific rule in Switzerland that you mustn't subject the party to an award on unforeseeable grounds. And that's the compromise between INC and the right to argue, that the parties they can't be expected to deal with unforeseeable things, but they're expected to deal with matters that are obvious, or not just obvious, but are clearly before them. And that's what I say was the principle, and the significance of that is that when the funds complained about a lack of due process before the Brazilian courts, and you remember that one of the headings was suppressor, they made exactly these complaints. And these were exactly the complaints that were dismissed. The court clearly understood the adversary principle, and you might think that a judge in a court of appeal has it in its blood to understand when something is a surprise. Looking at the record, the 14 files, this is not, and we look at this and say, well, we don't know what Article 148 is, but the courts obviously in Brazil know exactly how fraud sits in their civil court code, how important it is, how obvious it is to a litigant, what the consequences of that are. That's something that we can't understand, which is why estoppel is important. We can't put that into the same context. Now, can I just show you the evidence that demonstrates that the MP funds had notice of the fraud allegations? Start with the the written argument on the merits that was made by my client predecessors, as it were, at 1182. This is an early argument on the merits. It's not the final argument. 1182 to 1185, paragraph 37. I mean, skipping over all the numbers, if you read paragraphs 34 to 37.
Is this a written submission in the arbitration?
Yes, it is. Yeah. It's called the argument on the merits. It's dated 2009.
And so what stage in the arbitration would this have been presented?
It's a year before final argument.
After Mr. Lapjang given evidence, or?
I'm not sure that's right, but I'll check. His evidence starts.
Paragraphs 34 to 37.
Yeah. Well, they're referring to documents at that stage. The cross-examination, which starts at page 1404, I'm trying to find a date for it. I'm told I'm going to be given the date of the cross-examination, but at any rate, it's quite a long time before the arbitration concludes. The RG's arguments, final arguments on the merits, were on the 7th of January. So this is an earlier.
So you say 37 makes clear two things, doesn't it? One is that the conduct was deceitful, and the other is that he was manipulating the figures.
Yeah. And
38, it's put in as a basis for the alter ego argument.
Yes, because that's the characterization, but the facts are up to that, 37. But the facts are all there. The characterization is in 38, I accept, but on the basis that that isn't actually what binds the tribunal. What binds the tribunal are the facts. And then.
And so this is anticipating. But I mean, it's your submission, as I understand it, that this argument, founded on the documents, was accepted so far as the facts were concerned.
I'll show you that. I'll show you that when we get to it. I'm afraid I'm going to have to take you through the argument so you can see how often that word is mentioned when we go through it.
No, that would be helpful.
Manipulation. If you go to 1201, you see they again refer to manipulation of the balance sheet.
1201. Is this in the same document?
Same document, yeah. I'll tell you when I'm moving to another document, if that's okay. 1218, paragraph 184. So that's in that document. Then the final submission that was made by the client, my client, starts at page 1706, and that's also the first mention of manipulation, paragraph 2, 1706.
1706.
And you see what the argument is at 1705. That's the heading of the document. Then on page 1713, all the way to 1717, there's a description of the manipulation. know when you're ready for the next reference.
Well, there are some very serious allegations here put in terms of manipulation, abuse,
Yes.
unlawfulness of structures, and so forth.
Yes. And it carries on literally for quite a number of pages, but when you've got to there's paragraph 46 on 1718, which is fairly stark, over the page to paragraph 49. Second half of paragraph 49 on 1719 reads, Respondent 4 must be held directly liable because of its famous agent deliberately adulterated these figures with the sole purpose of deceiving claimant.
Sorry, which page is that?
1719, paragraph 49.
The higher than necessary, I mean, this was about double, as I recall, is that right?
About double, and there's a debate about how much they were responsible for, and they say that a part of it, and it's made in their case, that Chan only manipulated half the figures. But the point is, if you then produce a deceitful document, I don't know whether under Brazilian law that makes you liable for all the other loss, but that's what was said. And then we get to what the MP Fund said in their document,
yeah,
which is also interesting. First of all, just have a look at the index of their submissions on page 1843.
1843.
Yeah, the front page is...
Is this their opening or final?
Final. 1842 is the final argument. 1843 is the index, table contents, rather.
Yeah.
And just have a look at the following 3 pages, and while you're on the 1843, you can see that G, the headings under G are all directed at really well the sort of things we would say about non-reliance. You did a lot of due diligence, and so on. Appendix 3, H, is all about, well, there was nothing wrong with Appendix 3, and if there was, you see over the page, 1844, it wasn't us.
So your submission is this is a substantive response to the fraud allegations?
Yeah, on the facts.
On the facts by this...
By the respondent.
By this party?
Yeah. And then they say that the debt, part of the debt isn't part of the adjustment, nothing to do with us, no part of the claim. And then really they deal with the corporate veil argument very briefly at 1845. That's the only legal submission they make. And just looking at some of the detail, 1849, paragraphs 14 to 17.
Just give me one moment, please.
Sorry, one.
Okay.
So 17 is put quite generally.
Yeah. So 17, paragraph 17, yes. Quite generally, but then we have all the detail. If you go to page 1872, for example, and I'm just taking bits out of the contents. You can see there are pages devoted to this. Well, you did a lot of due diligence, you must have known. That starts 1872. Plaintiff, third from the line from the bottom, plaintiff had the opportunity to perform ample accounting due diligence prior to deciding. Figures were carefully analysed by plaintiff in-house. Battalion of attorneys and advisors conferred by Lapchand. Then on page 1875, Gol Group had ample and extensive advice provided by KPMG. 1876, 18 to 1877, it goes on. Aware of the business when it bought it. 1879 was satisfied with what it bought. 1884. They refer in paragraph 99 under now they're dealing with all the Appendix 3 issues. They then say, in order to attempt advances absurd theory of fraud, plaintiff and so on. And this fraud has nothing to do with misuse of a corporate structure. This isn't the alter ego argument at all. This is addressing head-on the factual allegations of fraud. And then you know, for example, on page 1900, Lapchan didn't do it. Mr. Nobre, who was the in-house accountant, did it. To suggest that the fraud allegations came as a surprise in the light of that.
I don't think it's being said that the fraud allegations came as a
Article
surprise.
148.
What's being said is that Article 148 came as a surprise.
Yes, but if you're in this system and you've got an allegation of deceit, and I'm not asking you to say whether Article 148 is obvious, but
it wasn't so obvious that your side's lawyers thought of it.
No, my side's lawyers clearly were asleep at the wheel in the sense that the claim they put wasn't legal claim, but they probably didn't. Maybe that doesn't matter in Brazil, because if you've made your allegations of fraud during the trial, and we all know that what fraud means here. We know that there's a deceit claim at common law, and they have direct fraud and counterparty fraud and third party fraud. That's 148. The judges in Brazil obviously know how easy it is to understand that. And they looked at this record and decided that there wasn't a surprise, that the party ought to have known what was coming. Just because it wasn't spelt out to them that there's a law of deceit in Darien Peak. I mean, that might be as obvious to them as Darien Peak. So and that's why I rely on an estoppel in that regard, because you can't be in a position to decide whether Article 148 is obvious when you've pleaded a lot of fraud. I mean, I don't know, and no one really can say that to you. No evidence unless we had a battalion of Brazilian lawyers giving evidence. But the Brazilian...
What we do know is the fact that your clients who wrote these voluminous submissions thought that their best and only argument was piercing the corporate veil.
Well, yes, but...
Well, respectfully, I'm not sure we do know that. It depends upon the correctness of the submission you're making to us, because if the submission that you're making to us were to be accepted by us, then precisely how it's characterised in the claim does not tie the hands of that party or the court, is your submission, as I understand it.
Yeah, you've seen that what the parties have done, or certainly what my clients have done, is thrown the kitchen sink at them for fraud and said they ought to be held directly liable. I mean, they don't at that point say under the alter ego theory, and so it must be the case that like the defendant, a plaintiff is entitled to say, I'm giving you all this material, Judge. We all know what Darien Peak is. Make your decision. They ought to be held directly liable.
That would be an easier submission to make if your clients hadn't pinned their colours to the alter ego masts in their submissions. If they simply, as it were, as you put it, thrown the fraud allegations
they did
at
both.
the tribunal and said to the tribunal, in effect, you decide what the legal effect of all that is, then you would be on much stronger ground, because then it could be said, well, the defendant should simply have anticipated that one of the bases for being held liable for fraud in Brazil is Article 148. But the difficulty is that it's as I understand it, it's a claim in tort rather than in contract. And the defendants say, well, we've been held liable on the basis we were parties to the contract.
Well, they did both. I mean, the thing is, they threw the kitchen sink at them and said that they should be directly liable. And they also argued alter ego. And when you look at the tribunal, it says, well, we reject the alter ego theory and we find them directly liable.
Or perhaps you should show us where your client's legal argument came at the end of their submission, or what they did say, that all the consequence of these factual allegations of fraud and manipulation were, because that's quite important in the way you put it.
Yeah, I mean, I've shown you the paragraph where they say they should be liable.
Sorry, is there a paragraph that says they should be directly liable?
That's paragraph
the paragraph
49.
I showed you.
Which one?
49 at page 1719. Is that the one?
Yeah. And
I see. One respondent 4. And respondent 4 is the
MP
It's
funds.
MP, isn't it?
Mm.
And if you look at the conclusion, all they say is that they be sentenced to pay the price adjustment. That's on page 1771.
1771.
And they don't even proceed it with an analysis of alter ego at that point.
It's paragraph 295. That's the 259. I beg your pardon. Is the one that you're focusing on? Is that right?
259, my lord.
259 in the conclusion.
Yeah, conclusions to, they're just asking for the price adjustment. And what the tribunal says, and I'll show you this, is that we order compensation in the amount of the price adjustment, which are coincidentally the same. You may have seen that in the reasoning.
Give me the reference to the conclusions. Page.
On page 1771, my lord.
Thank you very much. I was just looking at paragraph 46 again, which you referred us to.
Yeah.
And again, there's no reference there to alter ego, is there?
No. No, this is a straight allegation of fraud. And at the very least, that was one basis that was before the tribunal. And the courts, looking at what was before the tribunal and seeing a much greater volume than you have, and having also seen the witness, the tribunal saw the witness. I mean, do you remember there's quite an interesting passage in Mr. Lapchand's evidence where he keeps referring to garbage in, garbage out.
Yeah.
Mm. Remember that? Mm. The tribunal clearly took a fairly dim view. One passage is on page 1560. As I said, garbage in, garbage out when the question's put to him. I mean, the tribunal heard his evidence, took a dim view of him, saw these allegations of fraud. The cross-examination is on the basis that he's been fraudulently manipulating. None of that helps the alter ego theory. It's addressed in some detail by the other side in their submissions, none of which is really relevant to the alter ego theory. And then the issue for the, under Brazilian law, as it emerged from Mr. Santos, and I think is the bottom line, is the question is whether the tribunal finding a legal basis for deceit is a surprise. Well, that's a bit like saying to us, the tribunal mentioned Darien Peak, and we never had an opportunity to read the passages we wanted to from there. So can I just show you what the tribunal found? Starting on page 2112. How was the balance sheet prepared? 250 to 251. And on page 2130, they deal with the discrepancies related to the liabilities. They've dealt with discrepancies related to assets, and the liability discrepancies were by far the greatest. 2175, they deal with the claimant's allegations and allegation of fraud by Respondent 4.
Were the other respondents separately represented in the arbitration?
I believe.
Or was it just, as far as the direct, as far as the sellers were concerned, all they had to prove was obviously just the inaccuracy?
Yeah, I understand that by the end of the arbitration they were separately represented. Whether that was a trick or, I don't know. Because the sellers, remember, were economically under the control of the funds, as far as we're concerned.
Yes, no, I was just interested in whether the arguments, there was a separate argument as far as they were concerned, because obviously fraud was unnecessary as far as they're concerned.
Yeah, although in Brazil you have something called counterparty fraud, which is, I don't know. I mean, we don't distinguish.
Well, fraudulent breach of contracts, basically.
Basically.
Yeah.
Anyway, we have here, according to the claimant, Respondent 4 manipulated numbers. Doctored numbers were provided to KPMG. Fraud was perpetrated by Lap Chan. These are our allegations. And then claimant qualified Respondent 4's conduct as follows. And they refer to they refer to a number of allegations of essentially fraud. Quote them.
Where is that?
Give references. Paragraph 574 to 5.
Or 571.
571, yeah. And then once you go through that heading, you can see that there are a number of quotes given in paragraph 574.
Yeah.
These are from your submissions, presumably, that you were
Some,
just now.
yes, some of them are probably, but they seem to be picking up other stuff that I haven't seen. Claimant attributes such conduct directly to Respondent 4 and extends it to all other respondents. Claimant argues that bad faith and malice manifested itself in all respondents, that such malicious and fraudulent misconduct was only made possible through respondents' joint action, the corporate structure created. The arbitration tribunal, before describing respondents' position, wants to state for the record that the allegations of bad faith and the attribution of such conduct to all respondents are, as evidence from the previous paragraphs, continuously contained in claimant's writings ever since the beginning of this arbitration. Respondents had ample opportunity to address it. And then they summarize some of the responses of the fourth respondent on page 2177. You've seen that those are obviously quite detailed. 579 is broadly that Chan wasn't involved. 580 deals with the denial that the document was prepared by him.
He alleged that he wasn't involved at all.
He says he
Oh,
was,
not alone.
one submission they made was that he was travelling, and you can see that it's referred to in 579. He was travelling at the relevant time. And then KPMG did a lot of work. So they summarise the gist of what was being done. In their analysis at page 2178, they start off by looking at the petitum and the terms of reference. They quote from that. Paragraph 582. Now 588 at the bottom of that page, all the way to 596 on page 2180, deals their findings of Lapchan's manipulation of the books. They deal with reliance on page 2181, effect on the sellers, paragraph 600 to 602, and 631 on page 2186, 631 to 633. We then have
These passages, I think, are recited in the Court of Appeal judgment.
Yeah. And then we have the third-party malice stuff at 2184.
Sorry,
2184, my lord, is under the heading third party. This is their Darien Peak discussion, basically.
Yes.
And I don't know if 2186, paragraph 631 to 633 made it into the Court of Appeal, but 2186, that's fitting. It starts off on page 2185, fitting the facts into the concept of malice. So this is sort of what you'd expect in INC. I suggest they have found the facts, now I fit them into the concepts. Intention on 2185, causation or on 2186. And then they deal with the quantum loss on page 2187, holding them liable for the price adjustment and concluding in 643 that coincides with what they asked for, the same amount. So if I can summarize what I've been trying to show you, if you allow me to do that very briefly.
I think that would be very helpful.
So I'll do my best.
No, you take your time. Just
The court is examining whether the funds were deprived of the opportunity to present their case, to paraphrase Article 5.1b. In considering that opportunity and what was fair, the court should consider the expectation of the parties participating in this particular process, i.e. in arbitration in Brazil, assuming you accept my submission that it's done in accordance with the civil procedure principles of Brazil. I showed you Adams. You may have seen in the Court of Appeal the references at page 143, paragraph 150. To the like effect is the Court of Final Appeal in Hong Kong in a case called Hebei, which is quoted, H-E-I-B-I, Hebei. It's quoted in paragraph 150 of the Court of Sir Bernard Ricks's judgment. They're looking at it through the lens of somebody who's involved in proceedings like that. Thirdly, in considering that, you know that this is a system where parties are protected by the adversary principle, and in particular the rule that they shouldn't be unfairly surprised. Fourthly, although the tribunal relied on provisions of the Civil Code, which were mentioned by neither party, the allegations of deliberate fraud, reliance and causation were all debated before the tribunal. Fifthly, the Brazilian courts were asked to set aside the award on the basis it offended the adversary principle and found there was no violation. And the court should accept that finding when considering whether there has been a failure of substantial justice. And it should find that a person who plainly had notice of all the facts relevant to the case on an obvious form of liability, when the courts of Brazil were satisfied there was no surprise, cannot show that he suffered substantial injustice. And those are my submissions on natural justice, effectively. I understand that there's debate about the test for substantial justice. What I did manage to read in the extract, the Bourne extract, was that you don't apply English notions of natural justice. That's not the way it works. There has to be something supranational. You have to have some form of substantial injustice. And that all points to what we were really looking at yesterday. I don't believe that the debate will move very far from requiring proof of substantial injustice. That's my submission.
Are you relying on an issue estoppel in this context?
Yes.
So what is it precisely?
That there was no violation of the adversary principle as I've explained it. There was no surprise
under Brazilian law.
Yeah.
And that, you say, is a highly relevant consideration in deciding whether there's been a substantial injustice.
Yes.
Is that the way you put it?
Absolutely. I mean, you are obviously faced with enforcing many, England is faced with enforcing many awards from civilian jurisdictions which all adopt these concepts. And when these concepts have been observed, it's a bit extreme, and that's really why Sir Bernard Ricks ended up. It's extreme to then say that that isn't natural justice in the way we should understand it for enforcement purposes.
Well, that's a general submission, but you found that on the matrix of facts, findings, allegations that you've taken us through.
I do. What I did was really I showed you what the law is in those countries, and I showed you how it got to the courts, what the courts were likely to have looked at, how they could, how we can see how a foreign court could reach that decision, and then of course I rely on the actual decision. All that preceding it is just to show you that the argument has a lot more than just an estoppel. It has quite a lot of merit.
I mean, in paragraph 576 of the award is quite telling in a sense, isn't it? It's on page 2176, I think. Because the tribunal itself appears to have thought that because the respondents had had every opportunity to respond to the fraud allegations that were being levelled against them from the very outset, that was sufficient in itself.
Well, yes, I mean, they seem to think you've had an opportunity to respond. In fact, we know they did respond.
Yeah.
But they're really saying, look, if you wanted to make a point that you're not going to be liable for this, you had every opportunity to do that.
Yeah.
And I wouldn't, you know, if I was in front of a court and we had a trial about fraud, and no one talked about Darien Peak, and the court then goes away and finds liability. I mean, that's not actually that unusual. We don't talk about all the bases of liability in every case. No. Not when it's so obvious, not when every party is assuming something. But I mean, that's obviously it's different. But I showed you this because it demonstrates that there was a huge amount of debate about fraud in the arbitration. I could make my submissions on discretion quite briefly, but I suggest they're no less meritorious for that. Obviously, how you exercise the discretion has to depend on what, if any, grounds are established. I'm not suggesting that if you think everything is shown, that my learned friend says, that you would then exercise discretion. Discretion arises if you believe that only one of the grounds is established, and that ground has a lot of mitigating factors. For example, you might give some weight in that context to the Brazilian decisions. You might say they're not quite on point, but they're nearly there. And then you bear in mind in discretion that not only did the MP funds challenge it and appeal, they carried on appealing it to constitutional courts. They carried on appealing it to the highest court, and all those appeals and attempts to appeal were based on a lack of due process, if you like. And so I repeat what I said when I started, which is that this is really a very extreme case. There are very few cases, I haven't seen any case, where someone has repeatedly lost in the supervising court, has challenged the decision for 10 years as far as they could, and then try and do the same thing in the enforcing court. And here we are, same sort of thing. I can't remember when the ex parte order was made, a long time ago. And my clients were really entitled to believe there would be an end to these challenges when they finished in the supervising court. Remember, the supervising court cuts the whole tree down. You can't then go to the enforcing court. So they did the very most important challenge they could and lost. When they didn't like the judgment of the Court of Appeal, they went into Chapter 11. You may have seen that in the papers.
Is there any guidance on the exercise of the discretion?
I'm afraid not, because apart from Minmetal,
said not to be an open discretion.
Yeah, and almost everyone's dealing with it in a context where not like this at all. And of course, if serious grounds for annulling the award are found, it wouldn't be correct to have the discretion. But I don't know what you're going to find. But there is obviously scope for applying a discretion. There exists a discretion. No one disputes there exists a discretion. I'm really saying if ever there was a case for exercising it, if there's a modest fault in the award, then this is it.
Court of Appeal didn't have to decide at discretion.
No.
Sir Bernard Rick said that he would not exercise the discretion and gave no reasons.
He gave no reasons, so I don't understand why he said it. I'm not sure your lordship's in a better position. But he wasn't presented with a situation you might be in, where you might find some of the grounds sort of proved.
Well, if you found lack of due process, there wouldn't really be a discretion question, would there?
Well, you might say, okay, they weren't told about deceit, so applying Malicorp, that's bad. But given that this was actually okay in their own system, and given the way we've seen that they had all the material, and given that the Brazilian courts have already reviewed this, I can't give you hypothetical factors because I don't know how you would exercise, how you decide on the actual grounds.
Would it not be difficult to say that it was so egregious as to amount to a denial of due process and yet to apply the discretion?
Well, if you say it's so egregious, if you adopt that test, then it's going to be pretty inconsistent with discretion. Yeah. But it's if you adopt some other test. And it relates, I think, particularly to the terms of reference ground. If you look at, can I just ask you to look at, I think we quoted this in a footnote, it's page 4687 of the authorities. It's Lord Steyn in Lesotho.
Yeah.
I don't know if you need to, I mean, you might have seen it in my footnote. I assume no one reads footnotes, but page 4687 to 8, paragraphs 30 to 31, he discusses that ground in the New York Convention and says it ought to be strictly construed. He says although it's in excess of jurisdiction, it's quite unlike the other ones because it assumes the arbitration is valid. And so that might be a ground where, given the way, I mean, you might find, for example, that you might be satisfied with an issue stopper for the reasons we discussed earlier. You might say, oh, well, we're not going to rely on an issue stopper, and all they did was refer to the petitum and not the causes of action. Then I would invite you to say, well, this is a pretty weak ground, and that's why I'd ask you to exercise discretion, given all the appeals they've had. And those are really unless there's something else that you think I ought to deal with, those were my submissions.
Thank you very much. Yes.
My Lords, I'd like to take the reply points in the order of the heads of the appeal. So dealing with ground one first, consent and estoppel, starting with de novo review. Now, it is true that labels don't always help, but in this case they do. The point is that to found and issue estoppel, VRG have to show that the Brazilian court did determine the issues of fact and law for itself without deference to the reasoning or findings of fact or law given by the tribunal. And that is what is meant by the shorthand, a de novo review. It's what VRG have to establish, and we submit they haven't done so.
Well, you can have deference, can't you, Mr. Fenn?
No, I think one has to be quite careful, not deference. One can say, the court can say, I am exercising an independent judgment. I reach the same conclusion for the same reasons. That is not deference. That is an independent review that comes to the same conclusion. And that's why it's very important to have that in mind. Because in an ordinary case, it can be very difficult to determine what the court has done and how. In this case, more than most. But it is important that it is without deference to their reasoning on facts or law. And if it's with any deference, that is not a de novo review in this sense, and that is what they have to establish. They can't show that there are obviously degrees of deference. There was a distinction you've seen in some of the authorities between fact and law. Yeah. Do you defer to fact on a no-party case? But any deference, in my submission, is not a de novo review. Here we're way beyond that, but it is important that that is the distinction, and that is why we use that label, that shorthand. And that is what they must prove, and they haven't begun to do that. Now, what they do is suggest an alternative label. Ordinary judicial determination is their label. And in my submission, that's more apt to mislead in this context, because it doesn't tell the court anything about the standard of review or whether the court is determining issues of fact or law for itself without deference. It doesn't tell you anything. An ordinary judicial determination can be any number of standards. In this jurisdiction, and I hesitate to give examples from this jurisdiction because we're not dealing with this jurisdiction. But you have summary judgment, you have judicial review, you have Wensbury unreasonableness, all dealt with by way of an ordinary judicial determination in that context. That phrase doesn't help you in this case. It can help in other cases.
What sort of review are you contemplating here, given the nature of the issues?
In our case,
if it's not a determination or decision.
I'm not quibbling with what is being said. All I'm saying is that is misleading if it means anything other than de novo review.
No, but what sort of review are you saying would be possible in relation to issues such as are raised under Article 32.
Right, that would be a de novo issue. So that would be issues which have to be determined. In other words, in this country, let me give you an example. In this country, as of in Baltic, the first case, you have a hearing in a no-party case. So that's a case about whether a party is party to arbitration. The defendant says it's not. You have a trial before the arbitrators, you have witness evidence, you have documentary evidence, and the arbitrator reaches that conclusion. You then, if you challenge that under 67, you go to court, you go to the commercial court, and you have the same trial, which seems very odd, but you have that same determination. Now, if you have in mind Kebabji, I'm not in any way. It's not to do with. This is not to do with Kebabji. If the court in the commercial court decided that actually, like in any trial, was sufficient to be decided on a summary judgment basis, that is I accept that's an ordinary judicial determination. The court can apply its own standards. It's not a criticism of the court's standards, but the issue in this case is: did the Brazilian court apply a de novo approach in the sense that I've just identified? That's the question. Now, what is said against me is, well, it could have done that. It wasn't barred from doing that under the Brazilian arbitration law, but that isn't an answer. The question is, what did it do, not what could it do in this particular case. So I
think he goes further than that, really. I think Mr. Lowe says not only it could have done that, but it did do that because of the nature of the issues it had to determine.
Yes, but
because there were issues, for example, that were not for the arbitrators, they were for the court. And the court decides whatever it decides, and doesn't seem to distinguish between the way in which it dealt with issues the arbitrators had decided as opposed to issues that they hadn't.
In a sense, I accept that, but it's in my favour because the court is treating procedural issues and defects in the same way that it's treating the substantive jurisdiction, which is a different category of case. So that if on a challenge it's dealing with everything in the same way, in my submission, that clearly indicates they haven't taken a de novo approach to jurisdiction. They're not doing it on the basis that they simply start at the beginning and pay no deference to the reasoning of the tribunal. In a sense, that assists me, because it doesn't prove that there's been no deference one way or another. In a sense, it shows that there has been deference to what the tribunal decided. So all I'm saying about the alternative label is it doesn't advance the argument in any way, because it amounts to the same thing. What needs to be shown is that it's a de novo review in the sense that no deference is given, either in fact or law, to the findings of the tribunal. And I accept, Sir Julian, that the case against me is, well, if you look at it, it's all dealt with in the same way, although very difficult to determine how it actually is dealt with. But
in terms of issue estoppel, this is because you would say that would not be a decision on the merits, is it?
It's because it has to be done on. It's got to be an identical issue.
Yeah, we accept that.
Yes, exactly. And that imports the de novo review. It can't be by way of a deference. It's got to be an approach which is the same as the approach in this jurisdiction, which is de novo review, in the sense I've identified. And that's the core of it. And they haven't proved that. In my submission, they haven't begun to prove that. And that's at the heart of this issue. They must show that the decision reached by the Brazilian court determined the issues of fact and law, that's all of them, including jurisdiction and other issues, for itself, without deference to the reasoning or findings of fact or law given by the tribunal. That's at the heart of this issue. And that is the question that the court must address on estoppel. And the standard of review, which was actually applied, is an essential part of determining that issue. And it's a critical difference. It's not about the result, it's about the process. And that's why it's so important to have in mind deference. There should be no deference on fact or law. And if the Brazilian court asked, is there jurisdiction, after considering all the evidence for themselves and the law for themselves, once they have done that exercise, they might conclude that they get comfort from the fact that the tribunal have reached the same decision on the same basis. But they have to do that first. And that wouldn't be deference. And that standard review is very, very important. And the court simply doesn't have the basis to determine that. Just doesn't have it. They didn't provide the expert evidence. And it's a very difficult question, on which the court hasn't really been assisted, certainly not been assisted by VRG. The only point that was made orally was, well, Mr. Gomes Santos' third statement came in late, and that is somehow said to be our fault that they did not put in expert evidence on this issue. The first point on that is obvious. Even if it was an accurate statement, it's not an answer to the fact that they didn't serve any expert evidence on this issue when they have the burden of proving the estoppel. But I just want the court to know the first time that VRG stated that estoppel was being raised as an issue at the trial before Justice Mangatal was in their skeleton argument of the 6th of June 2018. And I would just like to show you a few passages from that so you can see how the issue arose. Because it seemed to be suggested that it was all our fault that this was dealt with in this way. If you go to paragraph, the first is paragraph 25 of their skeleton, page 350 of the bundle. Paragraph 25, first of all. The parties in these Brazilian proceedings are the same as the parties before the court now. If this were a final ruling, then the MP funds would be bound by these findings by means of an issue estoppel, if not res judicata. The only reason this may not now be so is because the MP funds have launched appeals, all of which have failed to date, and of none of which VRG submits have any sensible or reasonable prospect of success in the future. So that's the first...
the Nuvion point.
Sorry? Yes, that's the Nuvion point. And what's surprising about this is that they were running, until this, they were running construction only. Yet they nevertheless suddenly rely on issue estoppel for the first time in circumstances where there are pending appeals in Brazil. And as you know, they weren't finalised until after the Court of Appeal judgment. If you turn on, please, to 355, paragraph 36, what they say there is, whilst the decision of the tribunal itself is therefore not determinative for this court, the decision on the MP funds enforcement challenges in the Brazilian courts does give rise to an issue of estoppel, notwithstanding the fact that there was an application for leave to appeal outstanding. Yeah. So in a sense, nothing had changed because there were appeals pending when they started the proceedings, but it was only in this skeleton that we saw that for the first time. And then, if you go on, I mean, it does make the abandonment of construction all the more odd, because we thought that was the only point.
Why does any of this matter? Because they did raise issue estoppel before the judge.
Yes.
And they were either right or they were wrong.
It only matters because of what is said is that somehow this is our fault, that they didn't put in expert evidence on the point. They raised it for the first time in their skeleton. I'm not saying they couldn't raise it. Yeah. It's just simply that until then we thought that construction was the only argument. I do just want you to show you our response to that so you can see what we said in response. If you go to in our reply skeleton, it starts at 372, and the first paragraph is 1A.
37.
We deal in our reply only, we don't repeat ourselves, but in 1A we say we're dealing with the suggestion made by VRG for the first time in its skeleton that the Brazilian decisions...
What paragraph?
Sorry, 1A at 372.
Yeah.
Despite not being final in Brazil, give rise to an issue estoppel binding on this court. And then if you could turn on to 376, please. You'll see we then set out what the issues are in relation to that they need to be identified and so on. And then finally, just so that you have it, if you go on to 377, paragraph 16 to 22, you'll see that's where we set out our case on why it is that they didn't decide the same issue. And that is worth just drawing your attention to, that we raised exactly the points that we've raised here on the basis of Dalla, that it wasn't the same issue. At 19, for example, 19, since the law therefore does not mandate the Brazilian court to consider the same issue as the Cayman court, this is not a promising platform from which to contend that the Brazilian and Cayman courts are in fact considering identical issues. And then we go and we say, exactly as we say before this court, that the position is compounded when one looks at the judgments themselves. They are extremely difficult to follow. But what is clear is that the court was not conducting a fresh trial of its own on the question of jurisdiction, and the court did engage in a form of review of the correctness of the decision that the tribunal had in fact taken on jurisdiction, showing deference to it. So that's how the issue arose. It was for VRG to prove their case on estoppel, and they didn't do so. The only other point was made was that, well, there was a lot of material before the Brazilian court. Again, completely irrelevant. It doesn't tell you what standard of review is being applied. And Mr. Lowe yesterday spent a lot of time walking you through translated text of the Brazilian judgments and the Brazilian court submissions. Some of those, though, not even translated and in Portuguese only, same as the position below, inviting this court to decide for itself, without the assistance of expert evidence, what the Brazilian courts were doing. Now, we submit that that clearly demonstrates that it's a wholly inappropriate exercise. Courts simply cannot work out what was being done without the benefit of an expert explaining the position under the Brazilian arbitration law and Brazilian procedure and so on. And we submit it was always a very ambitious submission that the Brazilian court had conducted a de novo review, but impossible to do that without even adducing evidence on the point. So that was all I wanted to say about ground one. Turning to ground two, the right to be heard. And the first point is that raised by the panel, which is what is the right approach to the right to be heard under Article 5.1b? And the panel were asking in particular, what is the relevant applicable law under Article 5.1b? And we've provided the relevant extract from Professor Bourne's book. And we submit that the approach advocated in that text fully supports our submissions. And I'll just, if I may, tell you what our submissions are in the light of that document. Firstly, it is plain from that document that the applicable test is not that of the seat of the arbitration. In other words, in this case, it is certainly not Brazilian law. Professor Bourne says in his article, he refers to such a choice as making no sense. He says exactly that. And also it's inconsistent with the drafting history of the Convention. That's at page 50 of the extract. So what it is not is Brazilian law. Now, we submit that both the text and context indicate that the standard is an international one, but not one which is different under Cayman or English standards. And I think, I'll explain that in a moment, I think that was what Mr. Lowe was saying yesterday when he said that Cayman standards should reflect international standards. And if that is what he was saying, we agree with that. Professor Bourne says it's either the law of the Recognition Forum or of uniform international standards. But we would submit that they're not inconsistent or needn't be inconsistent. English or Cayman law should look to those uniform international standards rather than looking through the prism of domestic law or procedural niceties, as Professor Bourne puts it, rather than matters of fundamental fairness. So our submission is, it is an international standard. That is what the court is applying under that provision. But it is one that, in my submission, is also the same under Cayman or English standards, provided that it's accepted that it's concerned with issues of fundamental fairness rather than particular procedural differences or that any domestic court would take. What is also very clear is those procedural safeguards which are required under Article 5.1b include protection against surprise decisions. In other words, surprise decisions being those based upon factual or legal grounds that a party had no opportunity to address. That's in Professor Bourne's extract at page 53. And my understanding was that was common ground now, because on the basis of Mr. Lowe's submissions yesterday, where the summary of the book was put to Mr. Lowe, that was accepted. In other words, we thought yesterday it was common ground that the parties to an international arbitration should not be taken by surprise. That has always been our case. And I understood yesterday that is the position of VRG in the light of the extract from the book, which is at 3356, which was put to Mr. Lowe by Lego.
That's a different book.
Sorry, it's different. Yes, different book. But the proposition is the same, which is that the parties shouldn't be taken by surprise. Now, if that is the position, then much of VRG's case falls away. The only question on this aspect is, were we taken by surprise, in fact, not whether the issue of principle is there or not. But he then did take you to the book on Sweden and Switzerland and said that some jurisdictions, he said, do allow surprise. Some civil law jurisdictions do allow surprises. Now, I won't take up time with it now because we've dealt with it in
I think
detail.
it was more to as what amounts to surprise.
Yes.
Right, as to what amounts to surprise. Okay, fair enough. If that's the case, we dealt in detail with why we say that actually the book needs to be treated with some caution in relation to Sweden and Switzerland. But yes, if that's the case, I'll come to the factual dispute in a moment, if I may, but I'll just deal with Professor Bourne. Third point is the exception to the presumptive enforceability of an award is distinguishable from, but related to a tribunal's failure to comply with procedural requirements. That was something we've always said, which is, in this jurisdiction, a serious irregularity challenge is related to an enforcement challenge. They might be similar issues, but they're not the same. And the fourth point that Professor Bourne makes is that the parties are free to agree a fundamentally unfair procedure. But if they do so, they take the risk that the award will not be enforced under Article 5.1b, if there is no opportunity to be heard or there has been a breach of natural justice. That's at page 49, and it's also consistent with Min Metals, which Professor Bourne cites with approval in the article. The other point I would make is that, finally, the fifth point, there is a great deal in the article which is concerned with broader procedural defects. So in this aspect, one can be concerned with parties taking points like a refusal of the tribunal to permit disclosure, allowing or disallowing witness evidence, or indeed matters of scheduling of the hearing. And those aren't usually a basis for non-recognition because they're not serious procedural issues which have a material effect on the proceedings. They're the sort of issues characterised by Professor Bourne as following procedural niceties as opposed to be dealing with fundamental fairness. In this case, we are plainly, in my submission, dealing with issues of fundamental fairness. Now, so there is a separate question, which is whether this was, in fact, a surprise decision. And that, as I understand it, is now the core question on VRG's case, because of the exception that surprise decisions are not to be permitted in an international arbitration context. And that is a matter of fact. Now, the passages that Mr. Lowe took you to, as he did below before the Court of Appeal, in the arbitration concerning what he says are fraud allegations, were all for the purposes of establishing alter ego. That is a fraud on the corporate form, for the purposes of establishing a contract liability for the purchase price adjustment. They do not substitute for third-party tort liability. And Mr. Lowe accepted yesterday that the fairness standard is one of surprise, and at the core of our submissions are, it is surprising, to say the least, to be held liable as a non-party after being told you are a party for jurisdictional purposes. And it is surprising, secondly, to be held liable in tort in a contract case for a contract measure of damages. Or to put it in Lord Legate's phraseology, it is a surprise to find that you were required to open the tort books in a contract claim. And we are dealing with a fundamental change to the basis of liability. That would be enough in itself. But here, it's compounded by the fact that the new basis of liability, third-party liability, was inconsistent with the basis for finding substantive jurisdiction.
I'm not sure that's right, though, is it? Because what was found was that your clients were a party to the contract and therefore to the arbitration agreement, but that didn't make them a party to the obligations that were imposed on the seller.
Yes, well...
and I understand the argument to be, the Brazilian analysis, that a non-party means, for this purpose, a non-party to the warranty, not necessarily a non-party to the agreement.
Yes.
I think there's something in the arbitrator's award which
yes, but
puts it that way.
Even if that is the case, in my submission, it doesn't meet the point, which is, should my clients have predicted a claim against them under Article 148 in those circumstances? Now, one thing I'll show you, which we did an analysis of the Brazilian Civil Code. There are something like 30 possible claims in dolo or fraud. And so, in other words, we would have had to, or a party in these circumstances, would have had to have predicted that they might be liable simply because there is an allegation put as fraud on the contractual claim on the basis of alter ego, that the mention of the word fraud in the arbitration means that that party is put on notice that there might be a claim under any other provision in the code, not mentioned, not in the terms of reference, and that they ought to deal with that.
Well, it goes a bit further than that, I think. That's rather mischaracterising the case put against you. It's not a mention of the word fraud.
When I say, so there is a fraud allegation put fairly and squarely, let me put it this way, perhaps is better, fairly and squarely in relation to the alter ego claim. Even then, is it really the case that a party in those circumstances, having been brought in as a party, is to say, well, it could be analysed in such a way that we might be liable for third-party claims, and we might be liable for dolo under other heads of claim. Now, in my submission, that would be a surprise even if one wasn't in an arbitration context for the ICC, where you have terms of reference to meet exactly that point. Obviously, the difference between courts and arbitration is the court has a much broader inherent jurisdiction. Any claim can be brought. But in arbitration, it's defined by the consent of the parties, both in the arbitration agreement and in the submission agreement. And you can have a very broad arbitration agreement and a very narrow reference. But that, in my submission, makes it even stronger at the case in support of my clients, that there was no reasonable basis upon which that they could anticipate going outside the terms of reference for a tort claim, when only a contract claim had been brought. Now, I think I said yesterday that had it been the case that the claimant who didn't bring such a claim under Article 148, I mean, this is so alien to the common law approach, which is the party against whom the allegation is made is then to predict what the nature of the claim is, even though it's been proceeding on the basis of the contractual claim in terms of reference. So I accept that even if the case against me is that there was a clear claim of fraud, that is in relation to alter ego and third-party malice, and it would be quite wrong in my submission to require my client to go beyond the terms of reference and assume that that claim, or indeed any other claim, it wasn't as if that fraud allegation was made and it was said, well, this might be a claim under 148, or might allow a claim under some other provision of the code. The first time we see 148 is in the award itself. And in my submission, that is a paradigm case of surprise. You read the award, you know that serious allegations have been made against you. And look, one other thing on this is, it's all the more serious if an allegation of fraud is made and malice within the alter ego context, that my client should have the opportunity to address the nature of the claim that's made against them. They obviously have to address it for the purpose of the alter ego claim. But in my submission, it goes way beyond that to say that they therefore have to address it for any other potential claim that might be brought. And as I say, that would be the case even if we weren't in an ICC arbitration. Where you've got the ICC arbitration defining the scope of the reference, all the more so. And that, in my submission, is absolutely fundamental. It's fundamental fairness that a party should know that there's a claim against them under 148. Now, it's not this case that they're the same, because Article 148 required further and different facts to be proved than just the allegations of misrepresentation that were litigated for the purpose of an alter ego claim. Article 148 requires proof of reliance and causation of damage. Those are factual elements necessary to complete the legal claim for monetary relief. And what you can't do in my submission is treat this as if you're in a Derry and Peake situation in court. It's absolutely a false analogy. It's completely wrong to say that you should treat it as if you're in court, and if a judge in the commercial court or the Chancery Division saw a case of fraud, that might allow the judge to make a finding on Derry and Peake, even if that weren't alleged by the claimant. In this case, there are factual elements necessary to complete the legal claim for monetary relief, but those facts weren't presented or argued other than in connection with an alter ego claim, which doesn't require reliance or causation of damage. So in my submission, my clients never had the opportunity to litigate over the issues that would have arisen in 148 had they known about it. And ultimately the question here is, was this a surprise? And in my submission, absolutely was a surprise. And you can't just limit yourself to 148, because if you hold against my clients on this point, you're effectively deciding that if an allegation of fraud is made under a particular claim, it is incumbent upon that party to deal with any possibility within a civil code of where that might amount to dollar for other purposes.
Well, it all depends on the facts.
It does. In a sense, I agree. In a lot of this is about the spectrum, deference and so on. But in my submission, sorry, my lord, in my submission, this is absolutely the wrong side of the line.
But just backtrack a moment, and it may not be an answer. But you said a moment ago the reliance wasn't an issue, but it was an issue, wasn't it? I mean, reliance was an issue that was, or it was put in issue by your own client, or by Mr. Lap Chang.
But not for the purpose of one.
Well, never mind what the purpose was, but reliance was an issue before the arbitrators. It was an issue of fact before the arbitrators.
Well,
because it was said against. Against the claimant. Well, you never actually relied on any of this.
Yes,
because, for example, you did your own due diligence. So.
Yes, well, absolutely. But I think that there are 2 points. One is it necessary to prove reliance for the purpose of an alter ego claim? And our response may well have been, well, you didn't rely on it. But that isn't in the context of a 148.
Well, I'm trying to get to the bottom of the... Yeah. You're not suggesting, I don't think, that there were issues of fact that weren't explored before the tribunal. Well, we don't... It would have been explored if it were an Article 148 claim.
No, I don't accept that. There could be different facts that would be necessary for 148. Again, on this, you don't have any evidence about precisely what is necessary to prove for 148. If it had been raised, we may well have taken a different approach. We may well have raised issues about jurisdiction. The question is, if the claimant, why was VRG not raising this themselves? And although Lord Leggett has found a possible way through the analysis, in my submission the reason is because it would raise issues of jurisdiction at that stage. Because our case would be, well, hold on a minute, how can we be liable for a third-party claim when you've already found as an issue of estoppel that we're a party? And that would have raised a very significant issue, certainly not directly on 148, but that would have been an issue that would have been immediately apparent. That might explain why the claimant didn't raise it, didn't say, well, this serious case of fraud has been alleged. We would want to bring it in other ways, under 148, and we please tribunal, may we amend the terms of reference and bring that in. But this sidesteps all of that. And in my submission, ultimately where it comes down, is this a surprise? Absolutely, in my submission. It can't be right that by saying, well, there is a fraud allegation within a claim for an alter ego basis as a party, that imports an obligation on my client or other parties in my client's position to have to deal with any further possibility.
I understand the point you make about jurisdiction, but so far as the fraud allegation is concerned, we've been taken through it in detail, and we've been taken through your client's response to it. And your client's response to it was, it is submitted, resoundingly dismissed and rejected at every possible turn. Yeah. And so on the facts, I'm troubled by the notion that there is realistically another case you could have put forward. Leave aside jurisdiction.
Okay. But the answer, my lord, is that this is about fundamental fairness. What your lordship is applying here is a causation standard. The question is, did it make a difference? Now, that again is because we're in the realms of surprise and and it's accepted that a surprise decision is an issue of fundamental fairness. It isn't about the court going into the merits. This whole process of my submission is wrong because the court shouldn't be in the position that it's investigating the merits of the matter as it was before the tribunal.
It's not so much a question of investigating the merits, as I understand it, the way the argument is put against you. It is that there are these findings. We're not being invited to look at the merits at all. We're being invited to consider the way the cases were put and the findings that were made.
Well, yes, except yes, in a sense that is correct. But It's a claim for a claim under 148, which isn't in the terms of reference.
I understand
And that point, my lord, is fundamental, which is, was there an opportunity to be heard on Article 148, which is what it boils down to? And the answer to that question, my submission, is plainly there wasn't, because 148 wasn't raised. And that's the fundamental unfairness. Now, the point that's being made against me is, but hold on, there were fact findings. And there was broadly a causation issue, and there was an issue under the alter ego claim. And therefore you're looking at causation. Would it have made a difference? Query what the test is. Substantial distance, material distance. Is there a real prospect of successfully reaching a different conclusion? But in my submission, once one gets into that question, it's a red flag as to the wrong question being asked. If you're with me that we haven't been given the opportunity to address 148 because it wasn't mentioned, that is an issue of fundamental fairness. And the court, it's not appropriate for the court to work out what might have happened had that argument been advanced. You've got the jurisdiction point. Again, as I say, that looms very large. But even on the points of fact, we would be given the opportunity to look at those facts through a different prism. And
there were arguments about reliance, but I don't think, because it wouldn't have been relevant, that we've been shown any argument about whether the fraud that was found on the part of Mr. Lap Chang had caused the amount of the price discrepancy, which was the basis on which damages were calculated. Yes. Was that wouldn't have been relevant to a contractual claim?
So this point also imports the first issue, which is the court applying an international standard? And I hope, if you accept my submissions, we are looking at an international standard, no different to English law as properly interpreted. But then the question becomes, well, if in my submission you stop after the surprise, if you agree that we've been taken by surprise, the next question that your lordship is putting away, would it have made a difference? That then is, well, what is this? What is the test for that? What test is one applying?
But this is partly, which goes to the question of surprise, doesn't it?
Yeah.
Because as to how different it was, the analysis from...
That's the point, I think, isn't it? I mean, there's a sort of... I mean, I follow your point that as we were wading into the merits, you can see what difference would it have made. I understand that's not permissible, but I think part of exploring whether there really was a surprise is looking at what difference it actually made.
Yes, and can I just say...
because if you say, for example, I mean, I know you say the Darien Peak analogy is not a good one, and I follow that point. So, but I mean, in this jurisdiction, if you were found liable on the facts to have committed a fraudulent misrepresentation which had been relied upon to your detriment and caused loss and damage, then you wouldn't get very far with the argument that because the court had relied on Darien Peak, which you hadn't had an opportunity to address, you somehow were taken by surprise. Yes. I think that's Mr. Lowe's point.
Yeah, I understand that. And so that imports a number of different issues. The first point is that one has to be careful about putting oneself in the common law position.
No, I understand.
But that's the second one is one must be careful about putting oneself in court when this is an ICC arbitration where the reference is defined by the terms of reference. Yeah. And ultimately my answer to the question is this, that one doesn't get into the detail of the facts and the fact findings. One simply asks the question, what was in the terms of reference? Answer, a contractual claim. What did the award decide? Answer, 148. Is that a surprise? It is obviously, in my submission, a surprise. Because
if you're considering whether there's a surprise, it's relevant, isn't it, to have regard to the fact that this was an arbitration being conducted in accordance with the Brazilian Arbitration Act, and therefore Brazilian concepts of due process.
Well, I'll come to that in a moment, right, because that comes under ground 3, scope of the reference. But yes, so the first question is this. What is the test under Article 5? That has got nothing to do with Brazilian law.
Yeah, but let's assume the test is surprise.
Yes.
Or factually, whether they're surprised, you've got to have regard to the procedure which the parties were contemplating, which was according to...
I don't. No, I don't agree with that, my lord. No, because properly interpreted, Article 5 provides fundamental standards of fairness. So that would be the same in an inquisitorial system. It would be the same in INC if you were permitted to be surprised. Now, in my submission, you're not permitted to be surprised, and therefore, in a sense, it doesn't arise. But the fact that Brazilian law, put it this way, if Brazilian law allowed surprises, in my submission, that wouldn't be an answer.
It's not suggested that it does. What it suggests is that in considering on the facts whether you are surprised, it's relevant to have regard to what the procedure is in Brazil in terms of due process.
I don't agree. So Professor Bourne deals with that. He says the parties are free to agree a totally unfair system. They can do that. If they do that, and on that hypothesis, they wouldn't be surprised by a very bizarre outcome because they've agreed a bizarre process.
You can't be right, though, because picking up on my lord's point, imagine there were evidence that although you were going around saying you were factually surprised, suddenly a letter was produced where your client's lawyers said, well, actually, we anticipate that Article 148 might very well be the basis on which we were going to be held liable. We thought we'd better not mention it because we'd be giving the claimants the answer to the case. I know that's all hypothetical, but you couldn't possibly say in those circumstances that because by some objective international standard there might have been a surprise, there was in fact a surprise on the facts. Because there clearly wasn't. And I think that's all the point that my lord's putting to you. It has to be put in the context of being a Brazilian case.
But I think in those circumstances, it needs to be judged objectively. If for example, given the Professor Bourne's example, I just wanted to finish my example, because Professor Bourne says the parties are free to agree an entirely unfair procedure. The tribunal are masters of their own procedure, that is perfectly permissible. But if they do that, they take the risk on enforcement that it will breach the fundamental rights of due process and fairness. Now, taking your example, Sir Julian, both parties may well say that, well, it's not a surprise, the result, because we agreed a bizarre process, the tossing of a coin. And the fact that it fell tails means that one party has lost and one party has won. But they're not surprised by that. That is not a surprise in any sense of language. They expect that it's perfectly well within the bounds of the agreement that they had reached. But it's not an answer on enforcement. And I don't accept that if a client is advised, well, anything could happen, you're in a system where it just doesn't necessarily follow logic. What, is that to be held against a client? Because that means that in that system, anything can happen? I don't accept that. These are about fundamental principles of fairness. And even if a party did think, well, there's a possibility of an award outside the terms of reference, quite wrong, absolutely unprincipled, is a party to be said, well, you weren't surprised because you didn't think much of the arbitrators in that case, and you after the first day of the hearing, you lost all confidence in the tribunal, and you thought they could do anything. Now, I don't accept that would be a material factor. And so it is about the enforcement position. I think Professor Bourne's example is a very good one, which is free to agree something unreasonable and irrational, but don't think that doesn't come back in when you come to enforce. And it's not an answer. So I don't accept that the fact that they'd agreed Brazilian law and query what they did agree on the terms of reference. I mean, Brazilian law in my submission went to the substance of the dispute. How it went beyond that is a different matter.
But what do you say about Article 14.1?
Right. I'm going to come on to that, if I may. So that was what I wanted to say about ground 2. Ground 3, scope of the reference. Now, a similar point arises under Article 5.1c, which is what is the law applicable to the issue of the scope of the reference. Now, we sent you last night another extract from Professor Bourne on this area. I hope you've got that.
Not sure we...
Separately. We highlighted the passage. Do you have that, my lord?
Could you...
It's on page 70 of the...
It's separate. Yes, you're absolutely right. Page 70 of the hard... I'm so glad you've got the hard copy. It was sent separately, my lord, last night after our first one, and it's called Bourne on Article 1.
I don't think I got your first one.
51C.
What is the relevant?
So I got this one.
Sorry, the relevant page is 71.
Yeah.
71. It starts law applicable under Article 51C.
So the one I got, it's only got 25 pages.
I don't.
It's at the bottom.
There are two that we sent.
I think it's this passage here.
You got it.
Oh, 70 on the book.
So 70 in the hard copy, page 4 of the electronic.
Oh, okay.
Or in the electronic.
Oh, yes, I got
Towards the bottom of that page, law applicable under Article
Thank you.
51C.
Do you see it? Law applicable under Article.
Yeah.
Right. In contrast to Article 51A, 51C does not expressly address issues of applicable law. In some cases, choice of law issues will not be decisive, for objections under Article 51C will turn on issues of fact, i.e., identifying the claims and issues that the parties have submitted to the arbitrators during the arbitral proceedings. Now, that is on all four.
No.
I'm sorry, my lord.
Sorry. Do you have it in a hard copy as well?
No.
No. Have you got a hard copy of this? Because I
don't think so.
Thank you very much.
I'm highlighted the bit that was read out.
Thank you.
I'm so sorry, my lord. We took the guidance not to have our copies.
No, I think for various reasons it didn't find its way.
That page.
Is it not in
That
your
does
folder?
work sometimes. But
Thank you. Save wasting time. Thank you very much.
So, sorry, my lord. So this is page 71 of the hard copy at the bottom, under D, law applicable. And it's drawing contrast with Article 51A, which sets out the applicable law and says under 1C there isn't any. But he then says, choice of law issues will not be decisive for objections under Article 51C, which will turn on issues of fact, identifying the claims and issues that the parties have submitted to the arbitrators during the arbitral proceedings. And I think that was what Lord Leggett was asking about yesterday. When one interprets the terms of reference, what law does one apply? And here it's interesting that it's issues of fact that he's talking about. Nevertheless, there will be cases where the applicable law, the law applicable to the interpretation of an arbitration agreement, may be relevant or decisive, and it's important for the purposes of an analytical clarity to identify the law applicable under Article 51C. Now, just pausing there is a distinction in my submission between issues which go to the arbitration agreement, where one can see there's a stronger argument to say that you look to that law, construe the scope of the agreement.
Well, that's what the convention says.
Yes.
But this is a
But
different
the scope of the reference is different.
Yes.
And that's why I say that that's absolutely different. Nevertheless, there will be cases where the applicable law may be relevant or decisive, and it's important for the purpose of analytical clarity to identify the applicable law. And then he goes on with most national court decisions and other authorities under 1C do not address choice of law issues. A very few have suggested the law applicable should be the law governing the arbitration agreement, tracking the choice of law under Article 51A. That, he says, is difficult to reconcile with 51A, where in 1A you've got the reference to the applicable law, and 1C you haven't. That's his case. In a sense, it doesn't matter, because I'm, in one sense, neutral about the arbitration agreement. My focus is on the scope of the reference. More fundamentally, importing a national law standard into 1C's text ill serves the Convention's fundamental purpose, establishing uniform international standards, encouraging the recognition of arbitral awards. Now, we say, so far as the reference is concerned, it's an international standard. In other words, my submissions on the terms of reference here, it shouldn't have made any difference whether it was Brazil or England or whatever, because it's about construing the terms of reference, what was in, what was out. It's absolutely obvious that 148 wasn't in those terms of reference. But he says an international standard is correct. That is particularly true given the difficulties which inevitably arise in applying 1A's choice of formula to arbitration agreements. This difficulty is exacerbated under 1C by the fact that many accessible authority issues involve questions about the scope of the parties' claims or submissions in the arbitration, not readily subjected to the law designated by Article 51A. We adopt that as part of our submissions. That's absolutely right. Or about the subsequent meaning of the parties' underlying contract, then he goes into the contract. So it makes very little sense, he says, to attempt to force these various issues into the law, chosen by Article 51A, especially when the text of Article 51C makes no similar choice. On careful examination, national court authority under 51C conforms to this analysis. As discussed above, national courts have not addressed choice of law issues or applied national laws under Article 5.1a. Rather, national courts have adopted a standard of broad deference to the arbitrator's decisions regarding excessive authority and have interpreted arbitration agreements expansively. Properly construed, these principles have been derived from 1C and are a uniform international rule that governs determination whether the award exceeds the scope of the parties' submissions or arbitration agreement under 1C. Now, as I say, I don't need to rely on the arbitration agreement. I am, as I say, neutral about that, but I do say that so far as scope of the reference is concerned, that is an international standard. One can see, and I accept, that there is some force in the application of the law applicable to the arbitration agreement to determine the scope of that agreement. And I'm hesitant to attribute anything any longer, but I think that Lords Legge and Hamlin said that in Enca. But I don't, in a sense, that's not an issue before the panel now.
Well, isn't that rather important to whether there's an issue estoppel? Because if it's a question of Brazilian law, there may be an issue estoppel, whereas if it's a question of an international standard or perhaps an international standard incorporated in the law of the forum, then there's no issue estoppel.
Absolutely. In my case is there is no issue estoppel. Or my only submission on the agreement is my case on ground 3 is not about the scope of the arbitration agreement. It's only about the scope of the reference, and that's the only thing that this panel is concerned with. And on that, in my submission, supported by Professor Bourne and the terms of the convention itself, the applicable standard for a scope of reference is an international one, not the law of any particular national nation state, Brazil or any other. And that's why we submit we do get home on ground 3, regardless of the other issues. Because
even if it's an international standard, in interpreting the terms of reference, you would have regard, would you not, to Brazilian arbitration procedure, because that's what 14.1 tells you.
Oh, sorry. So yes, I promised to deal with 14. Can I deal with that? Sorry about that. 14 point. So the way this arose, I think, was Sir Julian yesterday saying 14.7.
I was looking at 14.7, but I think we've looked more at 14.6 this morning.
We have. So just let me go through all the provisions, because I think different members have raised different issues.
Yeah.
14.7.
Which page are we on? Sorry.
Sorry, 693.
Thank you.
It's in the judgment of the Court of Appeals.
So 14.6, I think, is the first one. That provision is about renvoi. So that's your standard renvoi position.
I'm sorry, just give me the page reference again.
Sorry, my lord. 693.
Yeah.
14.6. So that's the classic. In other words, it's Brazilian law, not by reference to any conflict of law positions in 14.6. 14.7, the arbitration panel should decide the matter submitted to it only in accordance with provisions of law and must base their decision on the laws of Brazil. We submit that is, again, that's a substantive law position rather than procedural law.
So what's that adding to the first part of 14.1?
Yes, so sorry, I'm going to go back to, sorry, I didn't take it in order, because I know, Lord Hamlin, you raised 14.1. 14.1 and 14.2 need to be read together. So 14.1, all disputes arising from or related to this agreement, including those concerning its validity, effectiveness, breach, interpretation, termination, rescission, so on, should be resolved in accordance with the arbitration law. And secondly, the dispute will be submitted to the ICC in accordance with the regulations in effect as of the date of the request for arbitration. Now, you have to read those two together. In my submission, what 14.1 is saying is that a broad arbitration clause, which means that all disputes arising from or related to this agreement, one doesn't know whether they have a Fiona Trust type approach, but under Brazilian law, all of those matters fall within the scope of the arbitration agreement, 14.1, and they have to be dealt with in accordance with the arbitration law in Brazil, seated in Brazil, Brazilian law. But 14.2 makes it clear that it's an ICC arbitration. Now, I don't accept that. So when you're looking at this, you have to construe it on the basis that the Brazilian law applies, but that doesn't change the fact that the tribunal are the masters of their own procedure. So the tribunal so it goes off, it's Brazilian law, Brazilian seat, no question that Brazilian law governs the substance. goes to ICC arbitration under 14.2, and the tribunal then decide what procedure they are applying. And that is dealt with in the terms of reference. So it doesn't, in my submission, really...
But the ICC rules in terms of reference don't touch on Article 21.2 principles. No.
No, but that's the reason for that is they're not incorporating the court procedures. They're not, in the terms of reference, had they...
Under 14.1, they're agreeing the arbitration is to be conducted in accordance with the Brazilian Arbitration Act,
Yes.
which includes 21.2.
Yes.
There's nothing in the ICC that says otherwise.
No. But no. So, for example, if they were challenging the proceedings in the seat, that would be governed by 14.1. The question is, what law governs the procedure of the arbitration? And what do you get out of 14.1 and 14.2? Now, my answer is this, that you get out of that you go to the ICC, you follow the ICC rules. In the terms of reference, you have to say which procedural law applies. If you're importing, for example, the law of the seat, here Brazilian law for purposes of procedure, the terms of reference would need to say so, and the terms of reference don't. And that is where you go with these. It doesn't give you an answer. It doesn't. What 14.1 and 14.1 and 14.2 do is they do not prescribe the procedure that the arbitrators can choose.
So what's the ICC rule that you're relying on in relation to procedural law?
I think it's 23.
Page.
If you hold on one moment, it's... Yes, so Article 23(1)(g), which is the same, it was the same in the 98 rules and the other rules. I don't have a reference to where it is, but it says that the terms of reference should provide particulars of the applicable rules. So the tribunal and the parties have to put their mind to what are the applicable rules.
23(1)(g).
23(1)(g).
Do we have the ICC rules?
I don't believe so, I'm afraid. I think...
And it says what?
It says that there should be particulars of the applicable rules.
And if there are not?
It's then governed by the terms of reference.
It depends on the rest of the arbitration.
Well, in other words, if it doesn't provide that Brazilian court procedures are to apply, then the tribunal are free to decide their own. They're not constrained by any procedures. It doesn't mean they are free to deal with the matter as in accordance with the terms of reference. They're not bound by any particular procedural rules. In other words, in order for a case to be put that they were bound by the Brazilian court procedures, it would need to say that, which it doesn't. So 14.1 and 42 in my submission don't provide an answer. They're the start of the journey in a sense. And you then end up with the terms of reference. Let's see if we can get to the rules. So on Article 5.1c, we submit that they were clearly different issues. Because it's very unclear. I think Lord Leggett asked yesterday, what law was the Brazilian court applying in the challenge proceedings? And it's quite hard to discern, but one would probably infer that they must have been applying Brazilian law. There's sort of no evidence they're applying anything else. But even if that is the case, the approach under 5.1c is a different issue. It's an international standard. And the Cayman court isn't bound in any sense by the findings of the Brazilian court, even if it can properly be said that the Brazilian court applied principles of Brazilian law. I'll just read it out to you. It's not in the record, but we have got it. So what the Article 23 says in terms, as soon as it's received the file from the Secretariat, the arbitral tribunal shall draw up, on the basis of documents or in the presence of the parties and in the light of their most recent submissions, a document defining its terms of reference. This document shall include the following particulars, and G is particulars of the applicable procedural rules and if such is the case, reference to the power conferred upon the arbitral tribunal to act as amiable compositor, which doesn't arise here. So, but it's the first part of it, particulars of the applicable procedural rules.
And in this case, nothing was said.
Nothing. And if you were to incorporate any procedural rules, rules of the seat or anything else, you would need to say so. So, my Lord,
but if you do, I mean, there's a separate head for whether the procedure has been in accordance with the law of the seat. That's a ground D challenge if it hasn't.
Yes.
The argument here is whether it came within the terms of the submission.
Exactly.
You say that's just an independent question.
Exactly.
It doesn't depend on any of this.
And that's what Professor Bourne says. It's sort of, in a sense, it's a question of fact. One asks oneself, was Article 148 in the terms of reference? The answer is plainly no. The point against me is, well, it might have been able to do that if you'd amended, because it's within the scope of the agreement. But that isn't an answer to whether it was in the terms of reference. And it shouldn't actually matter what law is applied, because every court should take the same approach, which is it in the terms of, in an ICC arbitration, is it in the terms of reference or isn't it? The answer to that is absolutely obvious in my submission. It isn't. It's not there.
Well, it's a point that Professor Bourne makes, isn't it, that in 99% of cases, if you like, the question is going to be an issue of fact, which is why the authorities don't deal with, such authorities there are on sea,
Yes.
don't deal with applicable law.
Yes, quite.
And you would say, well, here, it's a question of fact. Was Article 148 within the terms of the reference? Answer no.
And strictly as a matter of, he says it doesn't arise, but you do need analytical clarity, and the answer on the basis of analytical clarity is that you're applying an international standard. It may be a very simple question and straightforward, but it's an international standard not to be changed by what he calls, I think, procedural niceties of the domestic court. It's a straightforward question, but applying international standards. But on that basis, there is no issue of estoppel. There couldn't be, whatever the Brazilian court did. So well, that was all I wished to say, I think. Those were my submissions, unless the panel has any questions, further questions.
Could you please arrange for us to be supplied with the relevant extracts from the ICG 23.1?
Oh, Article 23, yes, of course.
Yes, Article 23.1.
I should tell you there are two, they're materially identical, but we'll provide you with both.
That would be helpful.
Can I just two small corrections, if I might, Lord?
Yes, of course.
There was evidence on what the MP fund said they would have done had they known about Article 148. And it wasn't drawn to your attention, so I'd like to do that. It's page 190.
Page?
190. Paragraph 40. That's what he says. Specifically, the MP funds would have addressed the specific intent, justifiable reliance and causation elements.
Sorry, what document was this?
Sorry, I'm so sorry. This is an affidavit of a Mr. Weiss.
Mr. Weiss's affidavit.
And this is a counterfactual piece of evidence, so it's what I would have done had I known. And I don't need to make any submissions about that sentence. I've already made submissions about what they did. I just thought you should see that, because that's what he says he would have done. I've made submissions about what they actually did. There's one other thing that my Lord Legate said that there wasn't any argument directed at quantum. If you look at 1843, the index of the fund submissions, remember that the loss was articulated as an overpayment equivalent to the capital adjustment. And under heading H on page 1843 are all the arguments about why the adjustment was not of the magnitude that was being alleged. In other words, these were arguments about quantum. If you go through them, you'll see.
I think what I was suggesting was that it may not have been relevant to a contractual claim to decide whether the amount of the requested price adjustment was caused by the misrepresentation.
Well, the causation was, I showed you the passages which dealt with causation.
And this was, look at them again. So.
Yeah, this is just supposed to be the quantum part.
Yeah, thank you.
My Lord, can I just say, I think what your Lordship is referring to is paragraph 102 of our case at page 2752, which is where we set out the material. So that may make it easier to look at the material.
Now, Mr. Lowe, you mentioned that you might welcome an opportunity to provide us with further submissions in relation to the Bourne document.
I'd just like to reserve a right to do so. I don't imagine that I can add very much to the debate that your Lordships were already having between yourselves on the subject, but I might do on the... sounded like Mr. Flynn wasn't saying anything very controversial on 51B. There may be something else I'd like to draw to your attention on 51C. I suspect the debate's a bit above my head, but I'll have a look.
Well, he's saying on both, it's an international standard.
Yeah, I mean, my point on 51C, and I think Lord Leggett put it to me, I can't really say anything else, is that the parties had raised this. They could raise it under the Brazilian Arbitration Act. They'd raised it, argued it, and argued it in whatever way they saw fit, and it was decided. And that's an estoppel on that issue, which is, the issue is, have you exceeded the terms of reference? I gave you the passage in Santos's evidence where he agreed that was 51C. He specifically agreed that that part of the Brazilian Arbitration Act was 51C.
Mm-hmm. I think one of the points being said against you is that if it's governed by international standard and not Brazilian law, then it may be a different issue.
It might be a different. It might be that we would answer it differently. They could have argued that in front of the courts. If that's how you interpret the terms of reference, they could have said, well, these are ICC terms of reference. We'd come in front of the commercial court here on that objection. I'm sure that would have been the argument, but they probably didn't. But the court decided it. I don't think in the light of that I'm going to say anything about 51C unless my client impresses on me that I'm being stupid and I've forgotten some important point.
Right. Thank you, Mr. Lowe. Mr. Flynn, is there anything you want to say in response to that?
No, I'm just slightly puzzled. If Mr. Lowe does want to put something in, or does put something in, presumably we should have a time limit, and
there will be a time limit, and we'll issue a direction.
I'm very grateful, but could we also, I anticipate that I may not want to come back to it, but could I have the liberty to do so if there was anything?
We'll give a direction in that regard as well.
Very grateful, my Lord.
Thank you very much. Well, we will consider all of the submissions that you've made to us with great care, both the written submissions and those that you've advanced to us during the course of the hearing, and we will issue the direction that I've mentioned, and we will give you our decision as soon as we can.